So today we're talking about extended leave with no medical documentation. And I just got done presenting at DMEC in St. Louis, and this came up a lot. It appears that some of the bigger companies, I'm assuming this is a strategy to avoid risk, have just put in, and this has been going on for a while, everybody, have just put in this basic strategy that everybody gets to be on leave for a year, and that should include not posting the job. And if it doesn't include not posting the job, that's not an ADA accommodation, everybody, because the ADA requires you to return them to their exact job. It's not FMLA. It's not any job that's similarly situated, etc. It's their actual job. And so if you're going to allow people to be extending leave for a year, that's sort of a company policy that you're doing that. And then at that point, you would need to engage in the interactive discussion and determine whether you can accommodate, because you should have been saving their job for a year. Now, what I saw was one of the companies I spoke with, their strategy was to literally send a letter that says your leave is fine, but by the way, your job isn't going to necessarily be there. And that's not under the ADA. That would be a company policy. You would want to go through the ADA interactive process first, everybody, to determine it was an undue hardship to keep providing excessive leave, not extensions, excessive leave beyond FMLA, or if they weren't eligible for FMLA, beyond 3 months, let's say, even if you would provide 3 months under ADA. With the American with Disabilities Act, once FMLA ends and you don't have a company policy that protects their job, then you're talking about the American with Disabilities Act if they still are reporting a medical condition that was not resolved with the FMLA. And then we're engaged in the interactive process. And one of the most important things about that interactive process is the employee is solely responsible at all times for providing ongoing medical certification confirming the need for leave or the need for an accommodation. And if you can't accommodate and your company is okay providing them excessive leave up to a year, because you're going to be doing it for everybody and holding their job open with temporary workers or because you have a big enough staff to manage it. And then at a year, you're really doing your serious ADA interactive process and determining whether it's an undue hardship. But if you actually don't have a policy and it's just been your practice to extend these leaves or even the implement an accommodation for that long a time, the most important question you always answer is this an undue hardship? Because if it's not an undue hardship, you'd be providing it anyway, but only, folks, only if they are acting in good faith and they are providing you a confirmed medical certificate from their medical provider that verifies what parts of their disability prevent them from being able to perform their job at the workplace. This includes those telecommuting things, those light duty certificates, the work from home, the extended leave. We don't just provide ADA accommodations because a doctor said light duty. We don't know what that means because they need leave with no end date. That's unpredictable, unreliable attendance, everybody. So when you step into this area, it is very clearly a strategy by organizations, probably coming from their attorney to reduce risk, to just let this happen. But then when you get to the end of it, if it's not managed correctly before you return them, or you are terminating because they can't come back, and you don't have those good faith interactive meeting records, we're going to be concerned because did you then not implement the ADA and you just did your company policy of a year? And then one of the questions that we got was, well, what do we do when we keep having employees continue to be gone and they've never provided a medical certificate? Well, under the ADA, you're ending that accommodation because it was temporary and they had to provide a certificate to confirm it. In our system that we train, We give them 3 opportunities to do that. It's about a 2.5, 3-week process. And if they still have not provided a medical certificate when we've sent them a certified letter asking for it, sent another one asking for it, and then gave them a 3-day notice that we're going to be denying the ADA because of their failure to engage in a good faith interactive process, and even under fee, hi everybody, read the directions on the interactive process. You have the right to have an employee provide you documentation that confirms how the disability impacts their ability to perform their job. We don't want the details of the disability. We just need a medical provider to explain why they can't work at the office. We need a medical provider to explain how long of a leave are they requesting. If a medical provider cannot tell us a return to work date, that's not a legitimate request under the ADA, everybody. That's unreliable, unreasonable absence. And if they do give you a return to work date and they don't come back, did the accommodation work? Because they're not coming back. And why would we extend it again if we really don't have a return to work date? And this is going to work again. Well, maybe we're generous, so we'll do that. And we do recommend that you probably do that at least once with a very, 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 very clear understanding. Employee ADA is a work regulation, not a leave regulation. FMLA is a leave regulation, everybody, but ADA is not. And under the ADA, we're expecting you to inform us how you can perform all the essential functions of your job at a meets expectation level with the accommodation. Now, think about this a minute. If you're taking leave for a month and a half and you don't come back under ADA, were you able to do all the essential functions of your job? Nope. And then you extended and asked for another 3 weeks and you still didn't come back? Are you performing all the essential functions of your job? No. So now it's an undue hardship to provide somebody unpredictable, unreliable attendance under the ADA because you will no longer be considered a qualified individual with a disability. So that's just in a nutshell what the ADA was meant for. And we were hoping that a whole bunch of the disabled people who are actually determined to be disabled, even by the Social Security Disability Administration, would be employed with this wonderful regulation. And we're using it a lot for our existing employees. So let's open our minds a little bit and see what we can really do with this regulation and remind our employees that if you're disabled and you can't perform your job functions at a meets expectations level, you're just not eligible for this kind of accommodation. So we're interested in your comments. And at this point, then, thank you so much for paying attention, and we hope to see you next week.